Vice President.
Senator Hussain, you have 15 more minutes.
Thank you very much, Mr. Vice President. And before we went on the break, Mr. Vice President, I was making the points of the issues with respect to the lawyer bashing and the issues with respect to cost. And then finally, I wrapped up on the issue regarding the filing of frivolous applications and the fact that the Attorney General would have known about the Malcolm Jones matter before it would have been filed, because the pre-action protocol letter and the JR application was both served on his office. So, Mr. Vice President, I want to move on to a new aspect of the FOIA amendment. And that deals with a very fundamental issue in Trinidad and Tobago. Mr. Vice President, you would know that by virtue of our Republican Constitution, it is enshrined in our law that there's a doctrine called the separation of powers doctrine. And if you look at the Constitution, Mr. Vice President, you would see that the Constitution is the supreme law and that Trinidad and Tobago is a sovereign democratic state. And the Privy Council would have examined what that means. That is Section 1 of the Constitution. And they found that there are three arms of the state, which is the legislature, which is the judiciary, and which is the executive. And one must not exercise the function of the other. But when you look at the FOIA legislation, and you look at the Freedom of Information Act in particular, at the definition section, you will see at Section 3, this is what a public authority means, Mr. Vice President. The same public authority that when it refuses a request has to hand over the information to the executive arm of the state, which is the Attorney General. And this is the definition of a public authority. The Parliament, a joint select committee of the Parliament or a committee of either House of Parliament. Public authority. The Court of Appeal, the High Court, the Industrial Court, the Tax Appeal Board, a Superior Court of Record. Courts of summary jurisdictions, the magistracy, the THA, municipal corporations, regional health authorities. And this will shock you, Mr. Vice President, a service commission. Now, we know the reason why service commissions in this country were insulated from the political arm, the executive of the state, was because of political interference in the hiring, Mr. Vice President, and appointments of certain positions that ought or have to be independent. So, Mr. Vice President, what this bill does is now tramples upon the constitutional boundaries of our Constitution, and it is in violation of the doctrine of separation of powers. Because how can you have, if I file a request to the judiciary or the Commissioner of Police or a service commission for personal information, Mr. Vice President, as long as that request is denied, the denial notice, together with the relevant material, is passed on to the Attorney General. Mr. Vice President, that is an extremely dangerous power that they are vesting in the Attorney General via this bill. Very dangerous power. Because you would now have the Clerk of the House, or you will have the Speaker of the House, the Commissioner of Police, having to go to the Attorney General to ask him whether or not I can continue to refuse this particular piece of information by the applicant. And where it drives a dagger in the heart of the doctrine of separation of powers is by the addition of 23A subsection 4. This is what it says. It says a public authority shall, a direction is given, comply with the advice given to it by the Attorney General under this section. Mr. Vice President, you will appreciate the danger in which a political head, Attorney General, is directing the independent arm of the parliament, the independent arm of the judiciary, the independent arm of the police, the service commissions, Mr. Vice President. And they what must? They shall comply with the advice of the Attorney General. Mr. Vice President, how can that be proper in a sovereign democratic state like Trinidad and Tobago? It is a sinister move by this government, Mr. Vice President. Sinister. And we cannot allow this. You have the country up in arms about this amendment. You have people protesting all over the country. It is all over social media. Every page you turn in any daily newspaper for about a week now, you have people complaining about this FYI legislation, asking for the government, asking to be heard on this matter. And what does the government say? No consultation. We have no time with the people of Trinidad and Tobago. 47. Mr. Vice President, could you imagine that? This bill has the ramification to deny persons or restrict or frustrate persons from accessing information in this country about how some of these state agencies work. And the reason why we are fighting so hard on this side of the House for this bill to be withdrawn, Mr. Vice President, is because when we come to this Parliament and we file questions holding this government to account, we don't get proper answers from this government. So we will have to access the freedom of information, because without that, Mr. Vice President, would you know that this country would have still been in the darkness with regards to the deal with Sandals? It was Afra Raymond who was in the doorstep, who was on the staircase of the courtroom in San Fernando, together with his attorney at law, fighting this government tooth and nail for them to disclose the memorandum of understanding that they signed with Sandals to give Sandals tax amnesty, to give them, sell out the country. That is what it was, exactly. Mr. Vice President. So that is why we must preserve this power so that we can access the court without hindrance, without obstacle, without frustration, so that we can hold this PNM government to account, because they have spent millions and billions of taxpayers' money and it has not benefited the people of Trinidad and Tobago. It has not. It has not. And Mr. Vice President, the Attorney General would have spoken about the Malcolm Jones matter, and that how the former Attorney General would have been in breach of the Companies Act with respect to giving certain advice to Petrotrin. Now, Mr. Vice President, I want to draw you to Section 60 of the Companies Act, which says that directors exercise the powers of the company directly or indirectly through the employees and agents of the company and the direct management of the business and affairs of the country. And the directors, Section 99 says that the directors have a fiduciary duty to the company to act honestly and in good faith with what? The best interests of the company, exercise care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. Now, a public authority, a state enterprise, that is incorporated by an act under the Companies Act, Mr. Vice President, will now be subject to the review of the Attorney General. So what if we have the Attorney General, and I'm not accusing this Attorney General, any Attorney General, because of a political motive, gives advice to a certain state enterprise, which is not keeping it with the director's fiduciary duty that it owes to the company. Mr. Vice President, the company will now run afoul of their fiduciary duties provided under Section 99 of the Companies Act. Because you will have a situation where the company and the Attorney General may be fighting with whose advice they should take. But, Mr. Vice President, this bill directs the state enterprise that they must act in accordance with the advice given by the Attorney General. How can that, again, be proper? That is improper, Mr. Vice President. Yeah, exactly. Senator Sobers just reminded me that all of these directors of state companies will now be exposed to liability for what? A cause of action in breach of a fiduciary duty, Mr. Vice President. So we have to be very careful when you legislate. But the Minister of Finance, he talked about the poor research. He said we have poor research on the side, very poor. But Mr. Vice President,
when did
he quoted, he accuses us, Mr. Vice President. Thank you. And Mr. Vice President, but had the Minister of Finance done his research, had he done his work, he quoted, I moved to the Central Bank Amendment. He said we should look at Jamaica. Let me look at Jamaica, how they deal with their central bank. Now there's a bill before the Jamaican Parliament called the Bank of Jamaica Amendment Bill 2018. It is before a joint select committee of the Jamaican Parliament. And Mr. Vice President, Mr. Vice President, Mr. Vice President, you know what that bill does in Jamaica? It modernizes and creates a more independent Bank of Jamaica. And the minister would have referred to the Minister of Finance in Jamaica being able to approve the salary of the Governor General once it goes above a certain limit and other employees of the bank. Do you know, Mr. Vice President, that amendment bill deletes the power of the minister? It erodes, it takes away that minister's power to approve the governor's salary. I have the bill here, Mr. Vice President. I have the bill. If you look at the bill, you will see that there's a deletion of the power at Section 6 of the bill. Clause 5, it amends Section 6 of that act. Mr. Vice President, so how could the Minister of Finance come here to quote Jamaica when Jamaica is going to make their Bank of Jamaica more independent by deleting the power of the Minister of Finance to approve the salary of the governor? Come now, man. It is laziness on the part of this government, Mr. Vice President. It is laziness. It is laziness. But I would have come here to hear that this government defend the Prime Minister's increase in his pension. But they stayed away from that for a while, especially the Minister in the Ministry of the Attorney General. I just like to correct the record. I referred to him as the acting Attorney General earlier. I'm to understand Minister Stuart Young is the acting Attorney General. Yes. But they talk about where they want to go. Jam Rock. They're quoting Jam Down. They're quoting from Jamaica, right, about the definition of salary, that it includes housing allowance. But I don't know how they didn't study the Jamaican legislation for the Prime Minister's pension. Because the Jamaican Prime Minister's Pension Act, here I would define salary, Mr. Vice President. Salary means the emoluments provided in the estimates of expenditure of the island, exclusive of duty allowance, entertainment allowance, or any other allowance or emoluments whatsoever, or any amount provided as contribution to the office, or any other expenses. Did you see housing allowance in the Prime Minister's pension there? Why you don't follow? You're only following one particular piece of legislation. You're cherry picking. When you want to quote, do everything across the board, Mr. Vice President. Do it across the board. Because when you have people in this country suffering, when you have mothers being denied their baby grant, when you have people lying down in the halls of a hospital on the ground because they can't get a bed, just remember that when the Prime Minister walks away from office, he has a housing allowance, while many of our people of this country remain without a shelter or a roof over their head, Mr. Vice President. Just remember that. This is brutal, Mr. Vice President. This is a brutal piece of legislation against the people of Trinidad and Tobago. You tell the people of Trinidad and Tobago that they must tighten their belt, that they must wean off the government. But I want to tell this PNM government that they must wean off the public purse and the treasury of Trinidad and Tobago. Wean off. That is what they must do, Mr. Vice President. It is hypocritical that they wanted this legislation that people can access information up until 180 days. They had to tack back. But they want to take central bank information in 7 days. Yes, this is the government freedom of information, you know. Yes. This clause in the bill that deals with central bank. This is their freedom of information. That is what they want. 7 days. But I must say, Mr. Vice President, that this problem, this piece of legislation was in existence for over 15 years. And no government ever complained about this particular legislation. The only one was this one led by the Honorable Keith Rowley, Mr. Vice President. You will see the figures will show that it was this government had the highest amount of refusals of FOIA requests in the history of Trinidad and Tobago. You know what that sends a signal? That shows that this government is the most corrupt government, Mr. Vice President. Mr. Vice President? Point of order. What is the point of order? 46. Yes, Senator.
No,
I have 2 seconds.
Yes, I understand that. That's why I'm... Minister and honorable senators, please allow me to rule. Senator Hussein, yes, that particular line that you're going down, as much as you're wrapping up, is imputing improper motives. I would ask you to refrain from that. Continue.
Thank you, Mr. Vice President. And to end on this point, that we need accountability in government. Because without this FOI legislation, we would have not known about the fake oil scandal. We would not known about scandal. And we will soon find out about the dragon gas deal, Mr. Vice President. And I thank you very much.
Senator Richards.
Thank you, Mr. Vice President, for recognizing me as I join this debate on the miscellaneous provisions, tax amnesty, pensions, freedom of information, national insurance, central bank, companies, and non-profit organization bill 2019. And let me say from the start that I will not be as theatrical as my colleague, Senator Hussein, who seems to be learning very well from the leader of his bench. And I say that in a complimentary way.
Thank you very much.
Mr. Vice President, I still consider myself a relative neophyte in the Parliament, but I must say that when I got the order paper and I looked at in the other place and I looked at the order paper for this bill, I was surprised, but it's a learning process because of the amalgamation of the disparate types of legislation being attempted to be amended. So it was kind of different for me, if not confusing in many ways. So I sought to frame my contribution, which from the very start I will say that there are several aspects of this that I fully agree with, and several aspects which I have great concerns, if not downright, outright disagreement with. For the government's part, most of it I agree with, but I will counter that by saying that the parts I disagree with, I disagree strongly with. So let me start by defining two words. Conflation. The merging of two or more sets of information, text, ideas, etc. into one. And another word I'd like to put as a foundation is inequity. A lack of fairness or justice, inequality. And I say that in the context of the two main parts of the bill that I intend to comment on, because I know the other members of the independent benches that will be commenting after me on several other parts. And I say that because it is confusing that something as sacrosanct and important as a freedom of information amendment is put amongst so many money-type bills in terms of the ability to effectively debate on them and elucidate the points that are necessary in their debate. Let me also start by saying there's no price that any state should put on good governance, accountability, and transparency, because the cost of unchecked corruption, inefficiency, and alleged malfeasance is almost too high to pay, as we've seen in many incarnations of governments in Trinidad and Tobago. And if my research holds correct, and the research of several political analysts in Trinidad and Tobago, the last 4 administrations were all voted out primarily because of allegations or acts of corruption. And this underscores the importance of any and all instruments in our legislative framework that uphold and strengthen the principles of accountability and transparency, including the very important Freedom of Information Act in Trinidad and Tobago. And I'll quote some documents elucidating that point. Because while I know, or I'm presuming, and I think accurately so, that this government and the last government are appreciative of the instrument that is the Freedom of Information Act, there are some nuances in terms of what this bill is presenting in terms of inserting the Attorney General officially in this, because the Attorney General, from my understanding from legal minds, as the state's legal advisor, has the remit to intervene in any matter at any stage if he or she feels that the state may have a case to proffer. So to insert it in this bill in this way, to me, is of great concern because of the political nature of any Attorney General. And I'm not speaking about the person, I'm speaking about the office in our system and the political nature or creature that is the Attorney General. In terms of, in this specific case, Mr. Vice President, the now extension of the time, if the public body refuses to pass over the information that's requested under the Freedom of Information Act as requested by any person. And I know the Speaker, Minister Hines, indicated that there had been some uncovering of what had been described as sinister attorneys or political activists presenting what he described as frivolous claims, clogging up the system and opening the state to paying millions of dollars in possible cost. I would have preferred, with such a strong accusation, the presentation of definitive data and the numbers of so-called frivolous claims and the cost to the state, because the substantive Attorney General has been commendably very good in the past at providing that type of data to substantiate claims upon which, in this case, these amendments are predicated. And that was not done in this case. And given the implications from several persons in the public domain, some of whom I'll quote later, in terms of the concerns of this extension and the insertion of the Attorney General, not necessarily this person, but the office as a political creature in this process, I think that would have been a better presentation in support of what has been described as the mischief that is trying to be corrected here. And I'm also concerned with that because, you know, when you look at, for example, and I'll quote a document by Esther Brimmer, and the title is Vigilance, Recognizing the Slow Erosion of Democracy. There are several questions that this document proffers that persons should be asking themselves, because very often in societies, the slide to anarchy and the erosion of democracy is not as steep or quick as we feel. It goes in very small increments until we can't even recognize the republic that we once recognized years ago. And we have to be very careful about slow and very incremental erosions of institutions of democracy like the Freedom of Information Act. And I'm not saying that this is the case here. I'm saying we have to protect against it because we never know who will occupy that office of Attorney General or the government that will be in charge of this institution in the future when we insert a political creature like an Attorney General into this equation. And before we know it, we can't even recognize the republic that we once treasured and the democracy that is fragile in our situation. I mean, a classic example of that, an analogy, is how we have accepted in Trinidad and Tobago persons on remand for 10 to 15 years. And we talk about due process and equality of treatment. That's another example of erosion of rights that is slow and now accepted in Trinidad and Tobago. And we have to guard against it fervently in the context of this Freedom of Information Act as a pillar of our democracy and our democratic processes and instruments in Trinidad and Tobago. So the observers in the document ask 4 key questions. Are the actions being conducted by a government entity? Do these actions affect the core functions of the democracy? Are there alternatives, or can the actions be sustained or changed to suit a wider popular view? And there's one that's a little more radical, but has a situation turned violent. And the other points that the document makes, Mr. Vice President, is how well are we monitoring how slowly or quickly these tools are eroding our democracy. And again, this is not directed at this Attorney General or this government, but we are seeking to insert into law the Attorney General taking up the issue 30 days after the refusal of the public body giving the information. So we have to ask ourselves these questions in the context of what may present itself in the future in Trinidad and Tobago. And is this amendment strengthening the democratic process in Trinidad and Tobago, or is the insertion of this political entity slowly eroding that, or possibly eroding that, or politicizing that? And I think many of the speakers before and in the public domain have suggested that it may not be supporting or strengthening it. It may be certainly eroding it, even in terms of, one, the delay envisioned, the extra 30 days, and two, the insertion of the political entity or creature that is the Attorney General. So I think we have to make that one of our strong considerations when debating or considering supporting or not supporting this kind of amendment. Many have spoken about the issue of accountability and transparency in the context of this Freedom of Information amendment in this bill. And I have to ask myself also, is the amendment going to make a big difference in terms of the reason proffered by the Minister in the Ministry of Legal Affairs earlier on in his presentation, or is it simply just going to kick the can down the road? Because to my understanding, that doesn't, even if it goes into the Office of the Attorney General for consideration, that doesn't negate the option for legal redress through the court system by those who have asked for the information in the first place. And if it does, I stand corrected, but by my understanding, it doesn't. So all it does is insert the Attorney General. He also has the remit to say no, and it can still go through the court system, still possibly costing the state millions of dollars. And I don't know that is what the intention or the stated intention of the amendment is. So that is of grave concern to me in terms of the amendment accomplishing what it set out to accomplish according to its presentation. Maybe what needs to be done, through you, Mr. Vice President, instead of institutionalizing inefficiency in these public bodies, which is basically what's happened over the years. Public bodies are not compliant, they have inordinate delays, they use exemptions in many cases which are codified as reasons for refusing to give information. And according to one of the speakers earlier, we live in a secretive type of society for one reason or another in terms of public bodies and their compliance. Maybe the way to go is to put systems in place, rules and regulations, to mandate efficiency in these cases. The Honourable Minister of Finance in his presentation spoke about the Bank of England and their Freedom of Information Department, which, because of the number of requests they have, they've put a department in place to facilitate that. The Minister in the Ministry of Legal Affairs spoke of the Parliament and its efficiency, where he asked for information and he got it in 3 days because a system is in place in those agencies. Instead of inserting this type of amendment, wouldn't it be more productive to ensure that public bodies understand that this is the day in which we live? It is a society in which we treasure accountability and transparency and efficiency, and we mandate that they put systems in place, an information officer, to ensure that it is done in a timely manner so that they don't reach to the stage of 30 days and in a timely manner, because part of what a democracy demands is transparency and accountability, the free flow of public information once it's not national security or medical records, as stated by the Minister of Finance, the Honourable Minister of Finance, in a timely manner, instead of accepting, as the Minister in the Ministry of Legal Affairs said, well, the police officer take long to go and take the report, and X and Y, and we end up just basically codifying the inefficiency. Because that's what we're doing. We're accepting, okay, well, and we always complain through you, Mr. Vice President, well, the public service is slow, and there's bureaucracy. But what we're doing here is saying, well, we accept it, we don't demand more of them, and we continue it. There's also, according to Section 38A of the Freedom of Information Act, Chapter 2202, and I quote, Part 1, a person aggrieved by the refusal of a public authority to grant access to an official document may, within 21 days of receiving notice of the refusal of Section 23(1), complain in writing to the Ombudsman, and the Ombudsman shall, after examining the document, if it exists, make such recommendations with respect to the granting of access to the document as he thinks fit within 30 days or as soon as practicable thereof. So there are existing options without inserting the AG into the equation. So why don't we place emphasis on strengthening the resources of the Office of the Ombudsman as an alternative approach than this, which has seen quite a bit of rejection from several quarters and can be easily seen as the politicization of the process. I think that is one of the options available to us, or remove many of the restrictions as are presently codified in public bodies that they seem to be using more and more to deny or delay information or the granting of access to information, with the exception, as I said before, national security and medical records, which is already in the law, and strengthen their ability to give resources to their departments which are responsible for submitting this information in a timely manner. That, to me, is a more acceptable route and within the present remit of the law as it stands. So I have grave concerns, not to mention, as has been mentioned before by our colleague Senator Hosein, and has been much discussed in the public domain, about the issue of the media and people like Afra Raymond and their fight, the literal fight under the present construct, that is, to get information which should be readily available to the public in matters of state that don't negatively impact or don't have relevance to national security or people's public records. And I have a quote from an online source, Wired 868, which takes a quote from Senior Counsel Martin Daly and former Ambassador and Head of the Public Service, Reginald Dumas, on grave concerns about many of the provisions in this miscellaneous provisions bill, and I quote, "Why is the government, which says it's committed to transparency, proposing to make it more difficult for citizens to access information from official sources? And why, at a time of economic belt-tightening and obvious rising unemployment, whatever the official pronouncement on the issue, does the government consider it a good idea to raise pensions for certain office holders whose emoluments are already well in excess of the country's norm at the expense of other taxpayers in certain pressing social needs?" And I'll deal with that part a little later on. But you see people who are respected commentators voicing similar concerns. The Media Association had the declaration of conflict immediately. I am a member of the media. Having serious concerns because it is already quite difficult, challenging, and a delayed process for members of the media who are a part of a critical institution of any democracy, the fourth estate, getting information on state agencies to conduct legitimate journalistic investigation, which have in the past proved useful to the sitting government and past governments in terms of unearthing corruption, inefficiency, government wastage, and malfeasance in the public service. The Media Association and its members have grave concerns about this Clause 7 and think it should be totally eliminated. I proffer an alternative, if not the total deletion of Clause 7, which would, on one hand, possibly remove the Attorney General from the equation because of the reasons I've outlined before, or two, ensure that public bodies enact measures, including, as I said before, removing of some of those restrictions and caveats that they have used to deny or delay the provision of the information to legitimate requests, and ensure that we make the system more efficient in the interest of transparency and accountability, which the present government has stood on from the time it was leading up to the 2015 elections and while in office. So I don't see it as anathema to stated government policy to do that. So if we can find a way to delete the insertion of the Attorney General, but strengthen the public's, and demand, quite frankly, the public body's ability and willingness and track record of providing information in a timely manner, I think we can come to some amicable compromise.
Sure. Senator Richards, in most instances, when a request is denied, from my experience, it is denied not because you couldn't provide it or you couldn't provide it fast enough, but you deny it on a perceived legal basis, that it could be challenged and it is not appropriate legally to so do. Will the advice come from as a government if it's not from the Attorney General?
Thank you. And my understanding, and please correct me if I'm wrong, is there's an option to kick in the office of the Solicitor General at that point to look over the situation and provide some sort of counsel. So there are already mechanisms in place, to my understanding. I don't see that the AG is the last bastion of state protection in this case for legitimate legal challenges. But on the other hand, Minister Khan, through you, Mr. Vice President, we know that we operate in an environment of secrecy. We know that public bodies delay and deny information that is legitimate because it may make them look bad. And by extension, in some instances, the government of the day. I'm not saying the present government, I'm saying government or administration. So we can't sit and pretend that it's always above board and it's in the interest of protecting the public body. It's very often in the interest of protecting the public body from proper scrutiny and protecting some possible malfeasance that may have come from the political directorate. So I don't think that it's anathema in terms of the suggestions that I've made, in terms of making the system more efficient and accountable, because as it stands, it's not. And in terms of response to the situation outlined by the Minister in the Ministry of Legal Affairs who presented earlier on, he's not here presently, and persons so-called frivolous requests, you know, at some point, let the public know as is legally possible. Because saying something in the open end, because there are political activists on both sides who can be accused of that. So it's not exclusive to one or two or three political parties. It may be people who have legitimate interest, we welcome back the Madam President, and people generally. It's almost like, yes, let's assume that the argument that there's mischief about is taking place. It's like Peter paying for Paul and, as usual, Paul paying for all. So people who have legitimate concerns are now hampered by this, and you add another layer of doubt and mistrust in the system by inserting the political creature that is the Attorney General. And I don't think that is a good move, especially in the divisive present political environment. And again, it is not a commentary on this Attorney General. It is on the office of the Attorney General and whoever may sit there in the future, whoever he or she may be, who may not be as magnanimous as this Attorney General or this government. We have to, the law has to have the foresight as to what is possible and stop at the point where it can be anathema to transparency and accountability. And I think that is very important. Through you, Madam President, my final comment on this, because I feel very strongly about this freedom of information provision that is proposed here. I really think the answer is to take out Clause 7 and strengthen those public bodies and possibly remove the impediments to them providing information which they've been using effectively. I want to quote from Freedom of Information, a comparative legal study by Toby Mendel, revised and updated in 2008 by Abdul Wahid Khan, Assistant Director General for Communication and Information at UNESCO. And I quote, "The free flow of information and ideas lies at the heart of every notion of democracy and is crucial for effective respect of human rights. In the absence of respect for the rights of freedom of expression, which includes the right to seek, receive, and impart information and ideas, it is not possible to exercise the right to vote, the right to investigate human rights abuses takes in secret, and there is no way to expose corrupt, inefficient government. The importance of the right to access information held by public bodies, something sometimes referred to as the right to know, has been recognized in Sweden for 200 years. And the right to know is also cloaked in the right to timely access to knowledge. It's not just about having access to knowledge, because very often the issues that are being interrogated by the request for information are time sensitive. So a 30 or 60 day or more delay may render the point that the investigator is trying to prove mute in a society like ours that moves pretty fast from one day to the next. So the delay aspect is also very important in terms of the provisions in this. And I continue quoting from this document. In 2003, the idea that the right to information had been internationally recognized as a fundamental human right was a bold claim, so the claim with phrases somewhat tentatively. This is no longer the case. There is widespread support for this contention. While there are no doubt of those who dispute the claim, they are flying in the face of history and in the face of increasing evidence to the contrary. Freedom of information is a fundamental human right and the touchstone of all freedoms to which the UN is consecrated. And again, I stress, the right to know also has a time component to it. It's not just the right to know 6 months down the road or 3 years down the road. It's the right to know as soon as is effective because of the systems you put in place to effect that efficiency. And we should not be codifying inefficiency, because that's what it seems like we're doing to me in this case, although that may not be the intention. Madam President, also, I just want to quote on this final point on this issue, the Organization of American States, Article 13 of the American Convention on Human Rights is a legally binding treaty, guarantees freedom of expression in similar terms and even stronger than UN instruments. In 1994, the Inter-American Press Association, a regional NGO, organized the Hemispheric Conference on Free Speech, which adopted the Declaration of Chapultepec, I'm sure I'm pronouncing that wrong, a set of principles which elaborate on the guarantee of freedom of expression. And underpinning freedom of expression in any society that is civilized and forward-thinking is the right to know, because expression should be predicated on knowledge and accurate information. It's not just about being free to say what you want in a vacuum. Your expression and your opinion, which is part of your right, has to be underpinned by your access to information. Otherwise, people just mouthing off, as we all hear, and it doesn't have any context or validity. So that's my comment on that. The other comment I would like to make through you, Madam President, is and I mentioned the word before you return to the chamber, which is conflation. So there's conflation between the various aspects of this bill, and there's conflation within certain aspects of the bill. And I am absolutely sure that the argument proffered by the Honourable Minister of Finance about judges and retired public servants who are struggling to take care of themselves is not lost on anyone. I am sure most people listening and looking on, and all commentators, have no problem making sure people who have served effectively in Trinidad and Tobago are taken care of by the state by these provisions. So I wholeheartedly support the emoluments for judges, etc., and persons who have in the past served. I, however, think that conflating it with prime ministers' pensions in the present environment and ministers with portfolio is where the contention lies. Because the government is on record as saying we have to belt tighten. And I'm not saying that ministers now and in the past have not given up their all. And we all know, at least I know, how demanding a minister's portfolio is. And the kinds of demands that are placed on any person serving in those honorable offices, and the fact that when you leave the office, in many cases, you can't get no work. Because nobody will touch you. You're a political agent. And that's a fact. We tend to have it easier. Let me not say we for this bench, that's anathema. And even so, because we are also a political creature of a different kind, also there's hands off of even independent senators because we vote on bills, because people have perceptions of us. So people who serve in these positions and other public officers have to be protected and taken care of the state. I'm in agreement with that wholeheartedly. Retired judges also fall into that category. You sat as a judge, and when you go back out and you may have retired, but you're not at the end of your productive life, because of the position you once held, it's difficult to get a job. To maintain your lifestyle, you can't practice again. So I am in agreement that persons in those positions and ministers should be taken care of, because the Honourable Minister, through you, Madam President of Finance, has been very good at prosecuting that case, and we are replete with individuals who we know, who, as Madam President indicated, through sensitivity, we will not call their name to demean their stature in society in any way, but we know of it. But when it is conflated in the public's perception with persons who the public already feel getting great salary, etc., I think there is where the concern is. And I know the conflation may have been strategic, because what government is going to come and say, you know what, let me increase our salaries and emoluments by itself? You're Galix. I understand that nuance in it, but that doesn't make you any less deserving of the emoluments, because one day you will not sit in the seats which you occupy now. But I think there needs to be some sort of consensus on it and find ways to present it so that it doesn't seem as if, and I'm being extremely sincere with this, self-serving in a manner of speaking and inequitable in a national context. Because the perception outside, and you listen to the talk shows, which are not really the repository sometimes of great information, but it gives the national community a chance to air their perspectives on things. I listened to a couple this morning, and people were generally upset of the notion that sitting ministers are going to get extra. But I mean, yes, they deserve it on one hand, but then when you're telling the population, people losing their jobs, it's a tight economy, and it is, and we have to be very tight about how we handle things, it just seems conflicting in many ways. And I understand it's not an easy fix, it's not an easy situation to resolve, but I think we have to have more discussion on it to see the way forward in the interest of, one, protecting the livelihood and standard of living, or not even protecting the standard of living of persons who have served, but making sure they have a decent standard of living, one, but also taking into consideration the fact that the public is looking on, and they have been asked to tighten their belts, and they don't have housing allowances and other allowances being tagged onto their overall packages when they leave their jobs. So that's a conflict that's not an easy one to resolve, but I think it must be considered moving forward. Madam President, also, you know, the other aspect, I agree with the amendment of the Nonprofit Organizations Act to extend it to a year, so that many of these organizations don't have the resources to comply within a year, so I think that's a good thing. And another thing, and again, I'm trying not to be self-serving in this, but I'm not even considering myself, but there are, under the present provisions of this, my understanding, and Minister of Finance, please correct me if I'm wrong, if a minister is appointed without parameters as outlined here for a day or a week, is he or she eligible, or is there a number of cycles that one must serve? Please.
You're referring to the pension issue?
Yes.
There's a scale. After 5 years, you get 1/6. After 9 years, you get 1/3. After 12 years, you get 1/2. No, after 15 years you get a half, and after 18 years you get 2/3, and that's unbroken service. When it's aggregated, they go much longer to 21 years to get 2/3, and then other increments. So no, if a minister serves for 1 day, he's not entitled to a pension at all. He has to serve for 5 years, and then he gets 1/6 of the amount, and then it just goes up progressively. But you have to serve 21 years if you have your services broken to get the 2/3. Okay?
Thank you. Thank you for the clarification, Minister. And the other thing I would suggest, and I know it's a difficult prospect in the context of what is already before us and the pushback in some areas, because I think, as I said before, not all aspects of these are unreasonable or unacceptable. But the issue of the classification of those within this House who are eligible, who become eligible. And I know it's been mentioned before by Senator Mark, and I'm certainly not proffering that people who serve 3 months or 3 years or 5 years, but certainly I know of independent senators who have served 3 terms or 2 terms and are not presently under this construct eligible. And they have also served, as the minister said in his presentation, admirably and well. And at some point, we need to have that consideration for them.
Senator Richards, you have 5 more minutes.
Thank you very much. Minister wanted to.
Yes, certainly. The issue with this matter is we didn't want to make it too complicated. There was a bill in 2014 that would have allowed persons without portfolio to make a contribution, because currently independent senators, opposition senators, and government senators without a portfolio are not members of the parliamentary pension scheme, so they don't make contributions, and therefore they're not entitled to benefits. There was a bill in 2014 to bring people like this into the system by just paying a small sum towards the pension scheme, not the full amount. But unfortunately, that bill was withdrawn. That is certainly something that should be considered in the future, certainly.
Thank you. Thank you, Minister, for the clarification. And finally, Madam President, on the issue of, I kind of lost my train of thought. So what I'll do is wrap up. To just outline my main points, I would prefer, I have no control over it, as the government fully admits, that in the interest of to me, exercising the intent of debate, that these kinds of bills not be combined. And I know the rationale is going to be, well, we're running out of time in this session, and we have a certain number of bills to pass, etc. But I don't think it's an acceptable excuse, and I say that without any derogatory intent. I don't think it's just in the interest of properly ventilating the issues related to these bills. So I guess better legislative and time schedule management would be in place, and we need to be very, very careful of not institutionalizing inefficiency in public bodies in terms of the access to information and the delay. And as I said before, and I'll close on this, it is very concerning to introduce the Attorney General's office in this equation. I think there are other ways to go about dealing with the alleged malfeasance and frivolous nature of things, but even that has its place in a democracy, because who's to say what is frivolous to you may not be frivolous to me? So you saying it's frivolous maybe because there's a political context in your concern, but it may not be to me, to be fair. And people have the right to information of public bodies. And with those few words, Madam President, I thank you.
Minister in the Ministry of Finance.
Thank you, Madam President, for allowing me the opportunity to join this debate. I will just address a couple of the issues raised by the preceding speakers before I get into the meat of my presentation, which will focus mainly on the amendment to the national insurance legislation and the tax amnesty. Madam President, Senator Hosein in his presentation said, in relation to another matter, the Freedom of Information Act, he said, people in this country who pay taxes have a right to know where their money is going. I would agree with that statement, but I am relating that statement to the amendment we are seeking to make to the central bank legislation. there are various provisions in the legislation in Trinidad and Tobago that protect privacy in the banking sector. The understanding on which that is based is that privacy is necessary for the protection of the financial sector, and also it is important to protect people's financial data. So that provision essentially is available in the financial institutions legislation, in the central bank legislation, in the income tax legislation. In all of those bits of legislation, there is a clear intent to ensure there's protection of financial data. This government is in no way seeking to interfere with that. What we are seeking to do is to get information on the staffing structure at the central bank and to get information on the remuneration paid to persons employed by the central bank. That, in my view, is not interfering with the financial sector, is not interfering with people's financial information, and is not seeking to violate any of those provisions in the legislation, with the possible exception of the provision in the Central Bank Act itself, which, when I looked at it prior to having to respond to a question raised by Senator Obika, I did not interpret to mean that the information on salaries and structure was not information that could have been provided. I didn't think it was information that was protected, because when I read a provision that says that the central bank officers are not allowed to reveal information that they receive in respect of the operations of the bank, I do not interpret that to mean salaries and staff structure. But it has been interpreted in that way, and what this results in is that the people of Trinidad and Tobago who are responsible for paying the salaries of the government of the central bank and others indirectly have no way of finding out how the central bank is structured and organized, what remunerations are paid. All we are seeking to do is change that, not to interfere with how they structure their affairs, not to interfere with the remuneration that is being paid, but I see no reason why people are not entitled to that information. And as I said, it in no way affects the provisions that protect the privacy of financial information in Trinidad and Tobago, which will continue to operate. Senator Hosein, again, throwing out bits for press bites, sound bites, says that if the Attorney General, in reviewing an application that is refused under the FIA, has to consider, and the application relates to the provision of tax information, then the Attorney General would have access to tax information through the back door, quote unquote. I think it's unreasonable for anybody to say that for the Attorney General to determine whether the Inland Revenue is entitled to provide tax information if that is requested, needs to look at somebody's tax return to make that determination. So what we are doing is trying to create concern and panic in the public where none should exist. All the Attorney General has to do is look at the application, look at the provisions of the legislation to determine whether there's a reasonable cause for saying that there is no basis for revealing this information. He doesn't have to look at people's tax returns. So let us not try to put misinformation out there where none should exist. Another comment made by Senator Hosein in respect of the Freedom of Information Act is if the Attorney General overrules a statutory body, then he is putting the directors of that body at risk of a breach of fiduciary duty claim. If the directors of a body acting properly on sound advice determine that this information should not be provided, then they have a reasonable basis for challenging any claims brought against them for breach of fiduciary duty. If, having refused to give that information, and the AG instructs them to do otherwise, and they act in accordance with legislation which says you have no choice how can a court find them in breach of fiduciary duty when they're acting properly in accordance with the legislation and their duties? So it seems to me that too is a frivolous claim. Moving on to Senator Richards' comments, I understand his concern regarding the need for more information. This government is certainly not seeking to reduce the public's right to access of information. What we are seeking to do is put a system in place that reduces the likely burden that the government will have to bear where applications are denied in a situation where there's little basis. The only time that an application under the FOI is required to be referred to the Attorney General is where the public authority to whom the application went says no. If the public authority in question says yes, the matter does not come before the Attorney General. Remember, the Attorney General represents the government in any application for judicial review in respect of which an application is denied. The Attorney General will be joined in that application. And we are saying it is wrong for the Attorney General for the first time to see this when the matter is filed and is already before the court, and then he has to go to defend a matter which he may not agree in the decision in respect of which he may not agree with. So Senator Richards asked for statistics, and I will attempt to provide some of those. The number of requests made to public authorities during the period 2009 to 2016 is what I have. I do not have the more recent years. So in 2009, you had 1,221, 2010, 1,556, 2012, 315, 2013, 818, 2014, 869 applications, 2015, 532, and in 2016, 899. The number of decisions that an applicant was told that he was not entitled to get access to the information, of the 1,200 in 2009, 128 were denied. Of the 1,500, I'm rounding up here, in 2010, 68 was denied. Of the 315 in 2012, 14 was denied. Of the 818 in 2013, 106 was denied. Of the 869 in 2014, 37 was denied. Of the 532 in 2015, 139 was denied. Of the 899 in 2016, 145 was denied. The compliance rate, yes.
Thank you, Minister. Through you, Madam President, would it not suggest to the government then that some sort of more efficient or accountable system needs to be put in place in these public bodies that are causing this issue, as opposed to the route that is suggested here? It seems that there is some issue with the decision-making process in these public bodies.
Okay. So let me finish with the statistics and I will come back to your question, Senator Richards. The compliance rate, that is the rate in respect of which yeses were given, average 84%. So it went from a high of 95.6, 95.7 in 2014 to a low of 83.8 in 2016. So it's been moving up and down, but the average is a compliance of 84% in respect of which yeses are received. The number of applications for judicial review filed where decisions have gone against the applicant, in 2009 it was 9. In 2010 it was 7. In 2011 it was 12. In 2012, it was 10. In 2014, it was 7. In 2015, it was 99. And in 2016, it was 107. So you see where we are going with applications for judicial review. The total percentage of judicial review in respect of the total made, it started out at 0.7, went to 0.4, 3.8, 1.2, 0.8, 2016, 18.6% judicial review applications. In 2016, 20.8% judicial review applications. And unfortunately, I do not have the figure in respect of which that costs the state. But I have heard the Attorney General speak on these matters, and he says in every case that has come recently, the complainant has been awarded costs in excess of $1 million. So it is a significant financial impact on the state, and it seems to be creeping in the wrong direction. And so we felt it was important to put a system in place which said, hold on, before we get to the stage where we have to incur $1 million plus in respect of each application, let somebody else who has to appear before the court and defend this decision, whether or not he was involved in the decision making, let somebody else have a say in this. Let somebody else have a say in determining whether the no should stay a no. And remember, the Attorney General only gets involved where it's a no. Where it's a yes, in the majority of cases, over 85% of the cases, they go straight to the applicant and the AG is not at all involved. Putting things in place to make things more efficient, yes, we agree completely we should do that. But remember, in the majority of cases, yeses are given, and in the majority of cases, the 30-day period is met. So, yes, there can be improvements in all cases, but it is not as dire as it appears. We are not seeking to institutionalize inefficiency. What we are seeking to do is stop this creep of cost against the state where decisions are made that may not necessarily be the right decisions. So that is what we are seeking to do with the Freedom of Information Act, to determine whether a no should remain a no or whether it should change to a yes. So in our view, we are actually giving the members of the public a greater ability to get the information that they're seeking by saying that somebody else can review a no to determine whether it should be a yes. So you won't have to incur the cost of going for judicial review in a case like that, unless the Attorney General agrees with the initial decision. So we are seeking to address what we consider to be a flaw in how the system operates, and to ensure that the spirit and intent of the Freedom of Information Act is adhered to. That is the objective of the amendment. We are not, I know we can always look around corners and say that the legislature or the government is creeping towards reducing the benefit of the Freedom of Information Act, but that is certainly not the intent, and it will not be the effect of this particular legislation. I don't think we should look forward to see what else could come in the future to determine how we treat with this particular provision. So I recommend to the members of the public that they give us support in respect of that provision for the benefit of the same taxpayer who wants the freedom of information and for the benefit of how we operate in Trinidad and Tobago. So, Madam President, having commented on that, I would like to switch to the meat of my provisions. And in that respect, I will refer to a comment made by Senator Mark in respect of the NIB. He says the NIB is shrinking. Government is bringing legislation to break the law. We should be increasing rather than decreasing contributions. And of course, we are breaching ILO conventions and so on. Madam President, I'm not sure that we, as a whole in the country, understand what the NIB does and what benefits are payable under the national insurance legislation. And so to understand the rationale for this provision, we have to have a clear understanding of the benefits that people are entitled to where they become registered under the NIS. So let me give a short synopsis of those benefits. And I'm looking here at short-term benefits because the particular provision, as you are probably aware, was contemplated in the context of us having to register migrants, who we hope are temporary migrants, to Trinidad and Tobago, who we are allowing to work, and who will therefore be in the system for at least a year. So the benefits which people registered under the NIS are entitled to are varied. And if we look at the short-term benefits and the rules around them, they are as follows. Sickness benefit. You're entitled to sickness benefit if you are registered with the NIB and you make 10 weekly contributions in the 13 weeks prior to the sickness. You must be in insurable employment, and you must be losing earnings as a result of the illness. Once you qualify, you're entitled to 60% of the weekly earnings, and this is payable for a maximum of 52 weeks. So somebody can make contributions for 10 weeks, but get 52 weeks of benefit. 52. Maternity, you are entitled to a maternity benefit once you make 10 contributions in the period in question. You are entitled to a funeral grant, which is a fixed amount. You are entitled to employment injury benefit. You get this employment injury benefit if you make at least one contribution to the NIS. So imagine somebody who is here for a short time, who is not a resident of Trinidad and Tobago, who has not contributed to the fabric of the society, being entitled after making one contribution to a benefit of 66 2/3 of their weekly earnings for up to 52 weeks. There's also a disablement pension, which you become entitled to once you have made one contribution. If you become disabled as a result of an accident at work, and you get this after the injury allowance, or what I called above the employment injury benefit. So you can get an injury benefit of up to 52 weeks, and thereafter you get a disablement pension. And it's potentially payable for life. So you get 1 year of allowance, you get a lifetime of disablement benefit after making one contribution towards the NIS. There's also a disablement grant, which is a lump sum. There's also a death benefit, which is payable after you make one contribution. And you are also entitled to medical expenses of up to $33,000 to cover doctor's fees, drugs, private hospitals, etc. Having said all of that, let's look at what the person must contribute to get these benefits. The NIS contributions currently, based on salary and wages, run from $9.60 per week to $110.80 per week. So imagine we have somebody in Trinidad and Tobago for a temporary purpose, having paid $906, is entitled to employment injury benefit, disablement pension, disablement grant, death benefit, refund of medical expenses. So if there's anything if there's anything that, to quote Senator Mark, will shrink the NIB, it is if we allow the abuse of these provisions. So what we are seeking the amendment to do is to allow us to review the circumstances to determine whether we should deny certain people the right to register and the right to get entitlement of these benefits. And this is for, remember, the Prime Minister and other persons from the government who have spoken on this say that we recognize our neighborly duties to our neighbors who are suffering pressure at this point in time. But we do that always in the context of recognizing our duty to the citizens of Trinidad and Tobago. And it is in seeking to protect the citizens of Trinidad and Tobago and to ensure that the NIS, which is already under pressure, as I have admitted in responses to questions brought to this House, that the NIS is not further eroded by an irresponsible extension of the benefits to persons who are here temporarily. That is the objective of the legislation, and I commend it to the members of the Senate to provide us with the support that we need to pass this legislation. Madam President, the last matter that I want to deal with is the amnesty. In that context, I will mention that before I joined this Honorable House, before I changed my profession, and long before I even contemplated whether I would get involved in this kind of activity at all, I worked in another place. And when the Minister of Finance in 2016 brought a provision for an amnesty, the place where I worked, PricewaterhouseCoopers, produced a tax newsletter dated July 2016. And one of the things we said, and I quote, "While past amnesties have resulted in the collection of a great deal of outstanding taxes, which would be most welcome at this time," and off record, it still will be welcome at this time, back on, "we are of the view that any further amnesty should have immediately preceded the introduction of the Revenue Authority with a new and more focused approach to tax administration." I say that in the context of Trinidad and Tobago having over the years granted amnesties in 2000, 2007, 2010, 2015, 2016, and began seeking to grant an amnesty in 2018. Now, an amnesty is a tool that is employed when tax administrations are not as efficient as they should be. Because what it is doing is saying to your taxpaying public, you have not complied with your tax obligations by not filing your returns and or not paying your taxes on time. So we will give you a period during which you can do that, and during that period, we will not impose the interest and penalties that would otherwise be due. So having recognized that the tax amnesty is to address inefficiency in the administration of taxes, it is reasonable to say, okay, having granted this amnesty, what are we going to do about this tax administration to ensure that this is not a recurring event? And what we propose to do, as I indicated, is to bring the Revenue Authority legislation before this House and again seek your support in getting that through so that we can ensure that going forward, tax compliance is more robust and the need for ongoing amnesties is significantly reduced. So let us understand what this amnesty means. Firstly, this particular amnesty, and of course, again, in the context of a situation where we are hoping to morph very shortly into a revenue authority, this particular amnesty waives taxes in respect of a longer list of waives interest and penalties in respect of a longer list of taxes than we have in the past. So it covers income tax, corporation tax, withholding tax, unemployment levy, business levy, green fund levy, health surcharge, petroleum profits tax, supplemental petroleum tax, value-added tax, gaming tax, financial services tax, tourism, transfer taxes, land and building taxes, and the online purchase tax. And what it does, it says to taxpayers at large that during the period June 15th to September 15th, you have the opportunity to settle all your outstanding taxes and pay all of your, and file all your outstanding returns with the Board of Inland Revenue. And if you do that within this period, we will waive the interest and penalty that would otherwise be due on the late filing of your returns and the late payment of your taxes. If what it does not do is to waive any tax obligation that exists, what it also does not do is to extend that waiver beyond the amnesty period. So if you pay your tax, if you miss the amnesty period and you pay your tax a day after the amnesty comes to an end, all of the taxes and penalties that previously existed and that would have accrued during the period of the amnesty come right back in force. So you have that window to act. And some people are saying, is it long enough? We've lost 2 days. What are we doing? Remember that in the mid-year review, which happened over a month ago, 13th of April, we would have indicated to the public that this amnesty was coming. So,
may I ask, what was the rationale for starting on a Saturday? It escaped.
The Minister of Finance is anxious to answer that question, so I'll leave it alone. But having said that, what I'm saying is that people were alerted to the fact that the amnesty was coming, so they could have put their affairs in order and got themselves ready. So in that context, it is my view that they do not need an extended period, although the legislation does give the minister the power to extend it beyond the 15th of September, where he thinks it's reasonable to do so. So, as I said, people are aware the amnesty was coming, and they have been getting ready because I've been having all sorts of questions about when the amnesty is coming or what it covers, and they have essentially 3 months to act. The Board of Inland Revenue is prepared for what hopefully is an onslaught of people to come in and settle their affairs and become up to date. Because following the conclusion of this amnesty, Madam President, we expect more robust compliance provisions, we expect more robust compliance activity, and therefore those people who choose not to take advantage of the amnesty should be made to feel the full brunt of the legislation. And the Board of Inland Revenue does have significant authority in terms of its compliance powers, and we expect them going forward to exercise those powers to keep people on track and keep them up to date in their payments and their filings. Because otherwise, Madam President, what happens is that the burden of the tax keeps falling on fewer and fewer people. And then the minister has to keep considering, do I need to adjust the tax rates to compensate for the shortfall in the tax? And the way to avoid or mitigate against that is to ensure that everybody who is required to pay what is required to be paid. And it is for this reason that the amnesty is being introduced. Now, one of the things that the amnesty does is to give those people who, before I say that, let me say that the interest and penalties imposed under the tax legislation are fairly hefty. And they're hefty because they're intended to act as a deterrent. So, for example, somebody who does not pay his withholding tax used to have a penalty of 50%, it's now 25%, plus interest at 20% on top of the tax and the penalty. Somebody who doesn't pay their VAT on time has interest of 2% per month, and so on and so forth. Somebody who doesn't pay their PAYE on time has penalty of 25% plus interest of 20% on the tax and the penalty. So these are all very significant. Also, the legislation gives to the Board of Inland Revenue the power, when it assesses somebody to additional tax over and above what that person has declared, to charge a penalty tax, so additional tax of up to 3 times the tax liability. All very significant. And so people who have not complied and who have, as a result, seen their taxes and tax obligation, when you include the penalties, go up to amounts that far exceed, in some instances, the tax liability itself, consider seriously, should I go and pay this tax and put myself on record so I know that the board is going to come after me, or should I try to stay under the radar and don't pay the tax at all? This amnesty gives those people the opportunity to regularize their situation without bearing the burden of those heavy taxes. And so we are hoping that by the end of it, we have a more comprehensive list of taxpayers than we currently do, which will help the Revenue Authority going forward. We have people who have paid up their taxes, and so we can look forward in respect of compliance issues, and that where we have to look back, the number of cases are fewer. So it will make the operation of the tax authority as we transition a smoother and easier transition. So it is for this reason and the reasons outlined by the Minister of Finance that we have brought the provisions of the tax amnesty at this point. And again, I commend that provision to you. I understand the concerns of senators that there are several different disparate provisions in this one legislation, but they are all significant, they are all important, they need to be done in a timely manner, and so it is for this reason that we have brought them together. It is not to slip anything by, it is to ensure that going forward we can operate in the manner that we need to operate to do things efficiently and properly. And with that, Madam President, I thank you.
Senator Ameen.
Thank you very much, Madam President. I take this opportunity to join in the debate for the Miscellaneous Provisions Bill 2019 that includes at least 6 measures that are unrelated or barely related, a measure for a tax amnesty, which is a mechanism for the government to scrape together more revenue, a measure for the government to pay itself more and members of the House of Representatives, the President, the Prime Minister, and judges more in a time when citizens are losing jobs, are being denied their back pay and allowances, a measure to restrict citizens' access to information under the Freedom of Information Act in a time where the government has publicly declared the purpose of this measure is to, quote, stop UNC lawyers from accessing information on the PNM government, unquote, and to give the Attorney General, a political creature, the power to do so. Fourth, an amendment to deny certain persons coverage from the National Insurance Scheme under the National Insurance Board. These certain persons and the conditions we have no knowledge of because the order has not been made available to us. And this measure puts the citizens of Trinidad and Tobago at a disadvantage on the job market. It also seeks to amend the Central Bank Act to allow the minister to have access to information in the central bank as if it were a department of the Ministry of Finance, and the sixth measure gives the minister more control over non-profit in the Non-Profit Organization Act, which was only recently debated in this Parliament. Madam President, I intend to touch on a few and to go in depth on a couple. First of all, Madam Vice President, I appreciate the frankness of the speaker before me, the minister in the Ministry of Finance. The measure to forgive the penalties and interest on taxes as proposed under the Income Tax Act, the Corporation Tax Act, the Petroleum Taxes Act, the Value Added Tax Act, the Miscellaneous Taxes Act, the Income Tax in aid of the Industry Act, the Tourism Development Act. All the taxes, all the revenue that would be collected in those places would be, all the unpaid would be forgiven, the penalties and interest. Madam President, I was happy to hear the Minister of Finance in laying the bill here indicate that a change has been made to correct an ambiguity in one of the provisions that would have allowed the penalties but not the interest balances for persons who had complied paying the principal before the amnesty period to also have the interest forgiven. And I think that was simply an oversight. It was not dealt with in the House of Representatives, and I intended to bring it to the Minister's attention today, and I'm happy that has been cleared up so that persons who complied would not be punished, as whereas persons who did not comply would be forgiven. Madam President, the date suggested, the date in this act is Saturday, 15th June 2019 to Sunday, 15th September 2019. I know it may have been selected because it may sound easy to say the 15th of June to the 15th of September. But effectively, there are a number of days where the offices would not be operational on a normal Monday to Friday, 8 to 4 operation as government offices are. I do know that there have been times when the Ministry of Finance would extend their opening hours into Saturdays and Sundays, and I trust that perhaps the minister, in clarifying the need for the data as indicated by the minister in the ministry, would you clarify whether the offices would be open on the Saturday and Sunday? The minister, my other question had to do with whether this would take effect after the proclamation of this act, and the minister has indicated that it will be retroactive, so any person who files on Saturday the 15th of June, I don't know if the office was open, would be forgiven. Madam President, we have had these amnesties granted on a number of occasions. The main incentive for this amnesty is not for goodwill. It is for that the government could provide an incentive for people who owe the state in taxes to come forward and pay them. It is a measure for the government to recover revenue that is owed to it. It is an opportunity for the government to have a little more dollars and cents to balance their books when it comes to the revenue of Trinidad and Tobago. And it brings into question the rate of penalties. The minister in the Ministry of Finance read out the rates in terms of the penalties, the interest, 25% on certain taxes. I will not repeat those, but I want to endorse, to indicate out of that, that the penalties, the rate of the penalties and the interest is meant to be a deterrent so that people would not pay late. But in fact, what it does is that because there is such a low compliance rate and such inefficiencies with the authorities going out and being proactive, it is easy for businesses and for individuals to err. And the moment these taxes are late, it is then easy to stay under the radar and to avoid paying the tax or wait until there is a penalty. So the question would come whether it would be more efficient for the government to consider on lowering the interests and penalties and leaving that as an incentive for people to pay, so that even if they pay late, the penalty is not so excruciating on their pocket that they have an incentive to not file. It is something that should be considered, because I know that taxes seems to be one of the measures that the government is heavily relying on. And I've spoken about the increasing a number of taxes over the years that I am not in support of. The other measure, Madam President, has to do, the third measure has to do with the second measure has to do with the government proposing to increase the pensions and the retiring allowances to the Prime Minister, the President, and judges. And Madam President, I don't intend to spend too much time on this, not because it isn't worthy of speaking out against, but because my colleagues will deal with it more in depth. But Madam President, I would suffice it to say at this time that we are in a period when many people are not losing their pensions alone. They are losing their jobs and their income. We are in a time when people are working, and they are working, the working poor. Teachers, nurses in our country, whom the very fabric of our country rely on, are indeed the working poor. We are in a time when even back pay for police officers is being restricted, and allowances for these essential services. They can't protest, they can't speak out. And they are being taken advantage of, and they are being told to tighten their belt. And in many instances, people have no choice. But here, and because of that, I don't dispute the argument of the government in terms of the decency in which you want people who serve in public office to retire and to be able to maintain themselves, or at least have enough to take care of their own medical expenses. I don't dispute those arguments. I am saying at this time, when the government is firing so many people, this is not the time for there to be an increase for government officials. And I leave that there. Madam President, the other measure has to do with the government's attempt to restrict citizens' access to information under the Freedom of Information Act. Madam President, I heard again today what we have been hearing in the public domain. The purpose of this measure from the government side is to stop UNC lawyers from abusing the system. It has been said by the sitting Attorney General. I believe the Minister in the Office of the Attorney General, MP Hines, repeated it today, and it has been said in other places by members of the government. Madam President, that is even more of an endorsement as to why a political creature should not be inserted in the procedure to obtain information under the Information Act. To give yourselves the power to intervene or interfere. This is not simply a notification, Madam President. This is an instruction that if a request is made for information and the agency does not feel it is fit to disclose that information, they must send that information to the desk of the Attorney General, a political creature, for him to decide if it should be denied or not. And if he does decide it should be denied, then the applicant could take it to court. What this does, Madam President, is provides for very sensitive information that an agency, it could be an independent body, it could be an arm of the government. If an agency decides that this information is too sensitive to disclose via the Freedom of Information Act, they have to send the information to the desk of the Attorney General. And so, information that is very sensitive, that could be pertaining to another government official, or pertaining to a member of the opposition, or pertaining to any person who objects to this government, could end up in the hands of the Attorney General, whereas he would not have been able to access it before. That, Madam President, is dangerous. While I understand the government's explanation that this is a measure to provide a sort of oversight to double-check on denied applications before it goes to court, and to provide the Attorney General a notification of the denial, Madam President, in other jurisdictions, this type of oversight is provided to an independent body. And that I could understand. Not an Attorney General, not a political creature. The objections have been far and wide from persons in the media, persons in the wider society. I pity my brother, Senator Harvey Boris, temporary senator. He's a man in the media, and he will have to vote today. He will have to vote on whether the government should restrict the freedom of information, whether the Attorney General, a political creature, should be inserted into the procedure. And I don't know how he will explain himself to his PNM colleagues and to his media colleagues. I'm sure it will be a bit of a pull and tug for him and his conscience to make a good decision. But I know his program is named The Hot Seat. Today indeed, he is in the hot seat.
He's nervous, he nearly threw on his glasses.
Madam President, the fourth measure has to do with the National Insurance Board. I intend to go in depth to that. So I will touch on the central bank, the fifth measure, which is for the minister to have access to certain information. And I said that it really reduces, it further erodes the independence of the central bank as an institution, and we have seen a number of institutions where that independence is being eroded by this government, and it is dangerous. It is a slippery slope. Senator Richards spoke about the steps that lead to the erosion of democracy and lead to the erosion of independence of organizations, and this is another step down that slippery slope that I do not agree with. The sixth measure has to do with the Minister of Finance being given more control we recently concluded debate on the Non-Profit Organization Act. And the amendment to that section 27 is amended to provide further control to the minister to determine, by virtue of an order, the period in which a non-profit company registered under the Companies Act may submit a completed AML, CFT, or PF risk assessment questionnaire to the Registrar General. Madam President, on this debate, during this debate, the opposition indicated that not enough, or in fact no consultation at all were done with the NGOs. During the committee stage, because we did go, we had a joint select committee, and the NGOs were happy to come and make their recommendations. And this matter would not have been discussed at that time. So here we have these two measures. They may seem small, but my question is whether there was any consultation with the NGOs. There were 47 NGOs at the time we were discussing that bill who were calling for consultation. So that is my question, whether that has been shared with the NGOs, whether we have had any agreement or consensus. And the fourth measure, which I now come back to, has to do with an amendment for the government to provide for an additional category in the National Insurance Scheme of Employment, an additional category of employment that is to be regarded as uninsurable employment and shall not be registered for the purposes of this Act. My first question, and the first question of any person, would be, what is the description of this category? What would be contained in this order? We have not seen the order. The minister, however, in laying the bill, did indicate that, and it was further endorsed by the minister and the ministry, that this measure is intended to deal with migrants and to deal with what they call preventing migrants from making contributions and from making claims, which would be a drain on the National Insurance Board. My first point is that this Parliament should not be asked to rubber stamp a power to be given to the minister, and we don't know what it will be used for. At least the draft order should be circulated so that we will know what we are getting into. The minister has indicated that it is meant to deal with migrants, but it doesn't. We don't only have to stick to that. He doesn't only have to stick to that. The minister could determine what is uninsurable employment even outside of migrants. And that, Madam President, is taking a rubber stamp from this Parliament to give blind approval to the minister. That I don't agree with. Madam President, I just want to share from an article entitled Social Security for Migrant Workers, a rights-based approach, and it was published by the ILO in 2011. And I'm sharing this only because the minister indicated that this measure is meant to deal with migrants. It says that any member of society, every person has a right to social security. Effective social security systems are powerful tools to provide income security, prevent and reduce poverty and inequality, and promote social inclusion and dignity. As an important investment in the well-being of workers and the population at large, Social Security enhances productivity, employability, and supports sustainable economic development. It goes on to say that increasing social security coordination between countries through bilateral and multilateral agreements and the ratification of relevant international conventions should be a high priority of social policy, as the well-being of millions of migrant workers and their family is at stake. The article acknowledged the need for coordination of social security provision between countries so that persons who are migrants would not fall subject to abuse. It recognized that migrant workers often face disadvantages in social security coverage and entitlements to benefits compared with national workers who live and complete their whole working life in one country. It spoke about migrant workers' social security rights may also be affected by the principle of nationality. The article also acknowledged that some countries discriminate against migrant workers through national legislation that excludes specific categories of migrants, or in extreme cases, all non-nationals from coverage or entitlement to social security benefit, or applies less favorable treatments to such groups on the basis of this principle. That is exactly what this government is doing, discriminating against migrant workers in Trinidad and Tobago. That is actually one of the main criticisms of countries in this report.
Well, deport them. Don't bring them and then discriminate.
Madam President, for example, the network of social security agreements is particularly dense among industrialized countries. So, for instance, the European Union, because you have so many workers from one country going to another country, they have to share information. They must as part of their bilateral and multilateral agreements, reveal the entitlements and the payments made by a worker in one country to another. What the report also mentioned is that there are instances where, because of the system of social security and sending information to the migrant countries, some of the countries might be significantly underdeveloped, and the administrative structure may not be very present, and in many cases they lack the capacity.
Senator Ameen, you're now really, I know you have been making reference to this report, but you're straying now from the central issue of this bill. So I'll ask you to try and come back to it, please. Okay?
Yes. Thank you, Madam President. I want to pin this back, the lack of structure, administrative structure, as indicated in this report, back to the situation of Trinidad and Venezuela, because that is what the minister indicated the purpose of the measure was for. But more or less, the fact is that the less developed countries where many migrants would flee from, sometimes because they are experiencing civil unrest or chaos within that country, it is difficult to have arrangements. That may be very relevant with Trinidad and Tobago and Venezuela, if not some of the other countries where migrants are coming to Trinidad. So for us, I think as a country, in order to protect the human rights of these persons, and it's not only Venezuelans, rather than proposing for these persons to be considered uninsurable, which violates their human rights, the minister should be giving consideration to some of the ILO recommendations. I am particularly concerned about the social protection for women, migrant women, and because migrant women would also qualify for benefits when it comes to maternity benefits, and for persons who may be injured on the job. The speakers on the government bench has indicated, compared the amount an insured person would have to pay as a contribution and compared it to almost a maximum of what they could get in benefits. But what they did not mention is that there would be hundreds of persons, or maybe thousands, who would be paying but would never make a claim. And that is how insurance works. That is how the cost and the benefits balance out. And in fact, the National Insurance Board returns a profit every year. So you can't tell me that a few migrants who might make a claim, who might get pregnant, who might get injured, would send the National Insurance Board into disarray and take all of its profits. Madam President, that is misleading. That is creating a picture to scare Trinidad and Tobago. The National Insurance Board has been returning a healthy profit, and I don't see...
Members, please, could we listen to Senator Ameen in silence? Those who do not want to hear Senator Ameen, you have the option of leaving the chamber for the time being. Senator Ameen, please continue.
Thank you, Madam President. Madam President, the ministers have created that fear, or try to create that fear, that perception, that if migrant workers are allowed to pay national insurance, and if they are allowed to make claims, that they would somehow drain the treasury of the National Insurance Board dry. That is far, far from the truth. Madam President, my second point with this measure is a question as to what is the basis of this recommendation. Is it that we had the recently concluded registration of Venezuelans in Trinidad, and so far it has been reported that roughly 14,000 have been registered, and of course we have no figure for the unregistered ones who are in this country. And my question to you, what facts have you been advised? What facts have advised you to put this measure in place? This should be informed by an actuary report. It cannot be that it is an arbitrary recommendation of a politician or a political party. That is not a basis to make such a change in legislation that affects the human rights of persons, whether they are citizens or migrants. This is another one of those VAPS recommendations and VAPS announcement that the governments make. The human rights aspect of this measure is very worrisome. But, Madam President, it is not only worrisome for the migrants who will, according to the indication of the minister, be considered uninsurable. This measure will have a serious impact on the citizens of Trinidad and Tobago. And let me explain why. When an employer is required to pay national insurance contributions for a national of Trinidad and Tobago, but they are not required to pay for a migrant or a non-citizen, who do you think they will give preference to hiring? Very often, migrants perform work that is beneath their qualifications. Migrants provide a pool of cheap labor for employers. And here we have a situation where so many people in Trinidad and Tobago are out of jobs, and you have thousands from Petrotrin, several from other government agencies, well-qualified persons who are jobless and facing the job market, doing work well beneath their qualifications. And here you have a measure that gives the employers in Trinidad and Tobago an incentive to employ a migrant over a national of Trinidad and Tobago. It puts our citizens at an unfair disadvantage.
Exactly.
So I want to warn the citizens of Trinidad and Tobago. Yes. While the government will pretend or come to us and tell us that this doesn't concern you, we really don't want the Venezuelans to make too many claims that would bust our pocket. Yes. I want to warn Trinidad and Tobago that this measure will have serious implications and put Trinidad and Tobago's jobless citizens and job-seeking citizens at a serious disadvantage when it comes to getting a job.
Those who are working in
Spanish.
Madam President, we have seen a number of major companies, major conglomerates putting out advertisement in the newspaper in different languages, namely Spanish. We are aware of the presence of not only Venezuelans, but people from African nations, a lot of people from Jamaica, many agencies, even government agencies we go to, we meet people from other Caribbean countries, particularly Jamaica, who, when it comes to security and so on, security firms and so on. So, and many of them tell you stories of being taken advantage of. They are exploited. They are paid lower wages than their Trinidadian counterparts. Very often, the company seems to have a high number of migrants as employees, and this is because it is a cost advantage for them.
Exactly.
They exploit workers, and we must ensure that no human being, citizen of Trinidad and Tobago or elsewhere, that their rights are violated, that they are exploited on the soil of Trinidad and Tobago. So for that reason, I want to ask the minister if he could share with us what his proposed order, what the contents might be, what the principles in that order might be, that would allow the protection of migrant workers, the protection of women in particular, and their children when they apply for maternity benefits or may qualify for maternity benefits. And I'm very, very concerned about that. The international organizations may have a say about this, as many of them have been keeping an eye on Trinidad and Tobago with the Venezuelan situation nearby so close. Madam President, I thank you, and I look forward to the wrapping up of the Honorable Minister.
Senator Deonarine.
Thank you, Madam President, for the opportunity to contribute to what seems to be a very controversial bill, the miscellaneous provisions, tax amnesty, pensions, freedom of information, national insurance, central bank, companies, and non-profit organizations bill 2019 as amended in the House of Representatives. Since this bill was introduced in the House of Representatives, Madam President, the voices of our democratic society has been loud, voicing concerns that this policy shift included in this bill is one that everyone should be concerned about. Some even feel that the content of this bill is a start of a gradual erosion of the democratic norms of society. The leaders of the country have to be cognizant of the fact that the role of the state, the size of the government, is very large, and any policy decisions are subjected to severe scrutiny because all of us are impacted some way or the other. At the same time, because we are in an energy economy, real growth derived from the expansion of the energy sector, which accounts for less than 5% of the population, is any benefits which accrue from this sector is very slow to trickle down to the regular man on the street. So today, Madam President, I would like to focus primarily on 4 aspects of this bill. That is the tax amnesty, clause 2, the retirement allowances for legislators, the president, the prime minister and judges, that is clauses 3 to 6, the Central Bank Act, clause 9, and the Freedom of Information Act, clause 7. Madam President, what I have drawn from this bill are the following. 1, citizens are being offered very commendably a fighting chance to come clean with their outstanding taxes and penalties before the government presses ahead with the TTRA. There's an enhancement of the retirement allowances of the past and present executive arm of our country, while still many public servants are waiting for their outstanding pensions. 3, the Minister of Finance is asking the Central Bank to disclose human resource information not readily accessible under the Freedom of Information Act to the regular citizens of the country. And 4, the time period to access information from public bodies have now been is being proposed to increase from 30 to 60 days and will now include the Attorney General, a politician who is trying to turn no's into yes, so that the people of the country can get some more information when a public authority says no. So I want to start by focusing on the tax amnesty. And I'm starting with the tax amnesty because I would like to start with the positive by commending the government for giving the citizens of the country a chance to pay their outstanding taxes for the period up to December 2018. I also commend the Minister of Finance for going an extra mile to waive the outstanding interest and penalties incurred on taxes, not only during the prescribed period, but also prior to such period. Given that our tax structure is one where most of our tax revenues come from individual income and profits, this is an easy short-term measure to raise revenues. So what I grasp is that the main objectives of this amnesty, as the Honorable Minister, both the Minister in the Ministry of Finance and the Honorable Minister of Finance has outlined, is that people are going to be allowed the opportunity to bring their taxes up to date. And more importantly, it is a short-term measure to generate additional cash flow for budgetary support. Now, I want to talk about this a little more, because what I'm wondering is why we have to end up resorting to this short-term measure. This is primarily because we are still reliant on the energy market. And once again, due to the dip in oil prices, there has been a shortfall in revenue earned during Q1 of fiscal 2018-2019, which resulted in very little supplemental petroleum taxes being earned. So in this instance, Madam President, we are expecting that the shortfall in the collection of supplemental petroleum tax will become compensated to some extent by the monies earned in the tax collection during the amnesty. I know we are expecting to collect around $500 million, but I am not sure what the extent of the shortfall in Q1 of fiscal 2018-2019 was. So I don't know if either one of the ministers could clarify that for me. So while taxpayers are being afforded the opportunity to reduce their tax liabilities, indirectly the government is hoping to encourage some sort of tax compliance. The fact that we are confident that we are going to earn $500 million or even more in the short space of time of merely 3 months, it is evident that we are very much aware of the extent of the lack of tax compliance. But to what extent should we expect the tax amnesty to increase compliance when the TTRA is established? Looking at the Auditor General's report on the public accounts of Trinidad and Tobago in 2018, specifically on page 33, it was reported that the arrears on taxes on incomes and profits recorded by the Ministry of Finance stands at $29.4 billion, of which companies alone account for 77%. Oil companies, $11.8 billion, non-oil companies, $10.8 billion. So given the extent of what I would call a lack of compliance that is clearly becoming a norm in the country, does the government have plans to implement a tax administration audit system to keep track of those taxpayers who are reporting on the previously undeclared incomes? Or are we waiting on establishing the TTRA before we kick in measures like that? How are we going to ensure that these so-called offenders are going to declare more accurately and honestly in the future? The point I'm trying to get here, Madam President, is that this is a short-run measure to increase immediate compliance. However, we need to be reminded that an amnesty should be followed by increased enforcement efforts to encourage continued compliance. Another point on the tax amnesty, Madam President, is that we need to remember that we are just coming out of an economic recession. Well, barely coming out of an economic recession. The government needs to be cognizant of the fact that many individuals and companies may not have the adequate cash flow available to meet their tax liabilities in this short space of time. That is the 3 months for which the tax amnesty is going to be provided for. Their tax burden can be excessive and correlate poorly with their ability to pay in 3 months' time. During these hard times, many companies and individuals in particular would have taken loans and are currently repaying debt, and also would have had to dip into their savings as well. So access to immediate cash flow to take advantage of the benefit may not be readily available. Given that many people may have committed to repaying debts and their savings are low, consideration should be given to extending this tax amnesty to maybe the next fiscal year. Now, Madam President, I want to move on to clauses 3 to 6 of the bill, which speaks to the retirement allowances. And I understand that, Madam President, I agree that the current and past executives who are serving and have served our beloved nation should continue to be honored with respect when they've retired. I also believe that they should not have to struggle financially upon emitting office. Not 1 year after, not 5 years after, not 10, not even 100 years after. The honorable ministers have very well painted quite a few examples here today of the suffering that some of our ex-executives had to encounter or is currently encountering. But with the most respect, Madam President, the country is not yet on a sustainable path of economic growth, real economic growth, to warrant such a policy shift. So I would caution the government on this move because the current fiscal situation must be taken into consideration before we commit to yet another form of recurrent expenditure. The CSO just recorded, well, I got information from the CSO earlier this year that the economy experienced quarterly real economic growth, that is growth in GDP, year on year, for 3 consecutive quarters in 2018. Quarter 1, 0.9%, quarter 2, 2.1%, quarter 3, 1.5%. Following 8 consecutive quarters of economic decline, Madam President, in these 8 consecutive quarters of economic contraction, at an average of 4.1%. And this turnaround that the CSO has recorded in 2018 has been primarily due to the uptick in the natural gas exploration and production, a sector that I have mentioned earlier accounts for less than 5% of the population's employment. Furthermore, the growth that we have recorded is taking some time to trickle down to the people of the country. Though we are forecasted to experience positive growth by the IMF, the reality is that we are still in the process of settling outstanding pension payments to public servants. We have to borrow to settle VAT refunds. We have to borrow to conduct most of our capital investment in the country. Our exchequer account is 40 billion in deficit. The overdraft in our central bank account, as the Honorable Minister would have clarified for me in an answer to one of the questions on notice, is $10.4 billion as of, I believe it was April 2018. The stock of debt is growing. We haven't heard what the long-term economic strategy to attain a balanced budget is. You have almost every ministry coming in front of us in the Public Administration Appropriation Committee and Public Accounts Enterprise Committee, expressing concerns about the lack of resources and allocations not being released in a timely fashion, etc. So, Madam President, these are the current challenges that we are still trying to overcome. So again, I question, is this the time to be committing the country to additional recurrent expenditure? The Honorable Minister has brought before this Parliament this policy measure. But just like other senators who have asked in this Honorable House, I am asking, what is the estimated annual cost? During this critical period of economic recovery, what is this estimated annual cost to the taxpayers for the implementation of this enhanced retirement allowance package? You see, Madam President, most respectfully, when we come forth with policy measures like these, it is hard for the average citizen of the country to swallow when they haven't themselves been feeling any ease in their pockets. It comes across as if the leaders of our country are making sure that they are taking care of themselves first. Madam President, I would move on from this matter. Now, I want to touch a little bit on Clause 9, the Central Bank Act. And with respect to Clause 9, it appears that the Minister of Finance is would like to access information from the Central Bank of Trinidad and Tobago, the human resource information, in particular, as the bill outlined, salaries and terms of conditions of directors, deputy directors, officers, and employees, the organizational structure, the number of current and former officers or employees, the number of filled vacant positions in the organizational structure, and other matters relating to the employment of staff as the minister thinks fit. So firstly, now I was listening to the debate in the other place, and I heard that the main reason for obtaining this information is administrative in nature. My question is, if it is administrative in nature, what exactly is it going to be used for? Is it just FYI, just for reference? If that is the case, then why not just include a provision in the Freedom of Information Act so that not only the Minister of Finance would access this information, but all the regular citizens of the country could access this information as well. Central banks in countries such as Canada, Australia, and England have an access to information policy which is covered under the Freedom of Information Act. Even if you get information on the salaries of persons and the perks of their jobs and so on, no personal details are given. For example, Amrita Deonarine is earning X dollars in the Central Bank of Trinidad and Tobago, just as an example. Secondly, I'm questioning, just like another senator has raised as well, why 7 days? What is the rationale for requesting this information and demanding information in 7 days? Also, with respect to E, other matters relating to the employment of staff as the minister thinks fit, respectfully, I do not agree with this. Other than it being too broad and it needs some definition, under no circumstances, other matters relating to the employment of staff should be demanded by the Minister of Finance. Because, Madam President, you already have that you're asking for the salaries and terms and conditions, the organizational structure, the number of former and current employers, the number of filled vacant positions in the organizational structure. What else is there that could be included under other matters relating to the employment of staff? So I would ask the Honorable Minister to clarify this for me. Now, I took the pleasure in going through the Central Bank of Trinidad and Tobago's Act. And I also see, I was quite surprised. I see that the Minister of Finance is already very well involved in the approval of many things, and also is also involved in the consultation on many aspects in the operations of the Central Bank of Trinidad and Tobago. And the human resource information is one of the very few things that the minister does not access. So, I mean, I know the minister said that this would not, indirectly during other person's presentation, that it will not harm the independence of the Central Bank of Trinidad and Tobago. But I'm just saying this for the record, that if the Honorable Minister gets this information and is in any way able to or tries to influence this role of hiring persons or the employment and terms of conditions of persons at the bank, at the Central Bank of Trinidad and Tobago, this can open up serious risks for the monetary policy decisions that the central bank can make. And the last thing I want to talk about, Madam President, before I conclude is, I know a lot of people would have spoken about the Freedom of Information Act, and I just have a couple questions, I believe. Right, so I'm wondering if the government at any point looked at why there has been an increase in the number of requests receiving no's. And what are the reasons for these increases in no's? Is it that information being requested is information captured under Part 4 of the Schedule of the Freedom of Information Act? Was an analysis done on the type of information public authorities have been declining to grant access to? Also, is the public aware of the rules and guidelines on the type of information they can and cannot access? Also, I do not know, and maybe this is just me seeking clarification as well, why does it have to take 30 days for a public authority to say no to a request? I think that if I receive a request for information, and I as a member of a public body, it shouldn't take no more than 2 weeks for me to be able to gauge or to decipher or to decide that no, I cannot provide this information. So, so I could understand the 30 days if they are able to provide the information. Anyway, with the involvement of the Attorney General, why does it have to take 30 days? And I guess it's because of the legal processes. I want to know what the process is. So I would humbly seek clarification from the Minister of Finance. Madam President, in terms of the freedom of information, we have to be reminded that the right to information is an anti-corruption tool. And any changes that will extend the length of time it takes to access information that belongs to the people of Trinidad and Tobago, and also anything that causes the inclusion of a politician, will leave room for speculation on the credibility of information that we will receive. I was looking at Canada, for example. Briefly, I was looking at Canada. And the Attorney General in Canada, who is also a cabinet member, is not involved in processing of requests for information. In Canada, each ministry establishes their own freedom of information department, and requests are reviewed internally by a person who is appointed by someone known as a privacy commissioner. So I would humbly seek clarification on these questions that I've raised. Madam President, I would begin to conclude, and I would say that I would end by echoing how I began this contribution today. Over the past few weeks, citizens of Trinidad and Tobago have been expressing their reservations about some of the clauses in this bill before us today. I urge my colleagues to listen to all sectors of society and not be dismissive of differing views. Here in our Republic of Trinidad and Tobago, no matter your creed, your race, your personal and economic standard, you must find an equal place and you must have an equal say. I thank you, Madam President.
Minister of Agriculture, Land and Fisheries.
Madam President, I thank you for the opportunity to speak on this miscellaneous provisions bill. There is something in this bill, Madam President, for all members to contribute on. And I would say this. There are some things in this bill, Madam President, that you simply cannot argue with. And that would be the proposed Clause 10 and the proposed Clause 11. Those are administrative with legal consequences, but very important. It gives the minister the discretion, with safeguards included, to extend the time for doing certain things, and I'll get to that. I don't think there could be much argument with proposed 10 and 11. Madam President, if relevance was important in this debate, not much could be argued about on the national insurance provision. Its submissions on it have been buttressed by irrelevance. The pensions, it's either you support it or you don't. And I'll get to that. And the amnesty is vital, not only because of the opportunity to get the taxes that are due, to get them in, but also in the context of two pieces of legislation we passed recently, the non-profit organizations legislation and the Explain Your Wealth legislation. It is an opportunity for individuals and corporations to clean up their records, bring their records up to date, file what has to be filed, pay what has to be paid, so that a level of accountability could begin. And the freedom of information, Madam President, people have flocked to that one with all manner of misinformation. Misinformation. It is simple. What is proposed is simple. It adds to what exists. It really doesn't derogate. And I am surprised. I am surprised that this has become something that has created an opportunity for so much misinformation that I hope to assist the public at least, and some of my colleagues here, in understanding that there's no harm in what we're doing here. So, Madam President, the amnesty provision, without destroying the opportunity for the penalties to be levied at a later occasion, the bill proposes that the amnesty be for a particular period in which people who come and pay what is due do not pay interest and penalties. However, Madam President, the tax that is due must be paid. And that is very clear in the proposed 2A and B, which set CD onward, which sets out the amnesty, and sub 3, which starts with beautiful words: for the avoidance of doubt, the waiver does not apply to the waiver of the outstanding tax, just the interest and penalties, and I think that is very important. And at sub 4, when the period expires, if you have not participated in the opportunity, then the penalties and interest will apply as though the waiver had not existed. And as I said, you can't really, we've seen, maybe the Minister of Finance has not collected as much as he expected to, but we have no doubt that the use of the amnesty has caused some people who would not have ordinarily paid up to come into the fold and pay up. The second area is, of course, the pensions, Madam President. And the arguments have been around three concepts that have been expressed without much depth in it: affordability, equity, and most importantly, how it will look. But Madam President, you know, before he sang a song that upset me, I really enjoyed listening to Buju Banton. One of my favorite songs is, "It's Not an Easy Road." And he says in that song, "It's not an easy road. Many see the glamour and the glitter. For them, they think it's a bed of rose. But he who feels it knows." And all legislators, let us not fool the public. This is not about an increase in pay for me. I am on record as saying I'm happy with what I get. I came into this job expecting to be an elected MP, and I know what went with it. And as fate would have it, I ended up in the cabinet, and I knew what went with that. But I'm also on record on the issue of salaries as saying our legislators need to be better paid. But this is not, the public has been led to believe that this is about increasing salaries. This is not about that.
Exactly.
Madam President, all those persons who we're talking about, employees, and nothing I say this evening should be seen as disrespectful to daily paid workers, monthly paid employees in the private and public sector, retirees, people on social welfare grants, and so on. Nothing I say suggests that they are not deserving of more. But Madam President, many of the people working in this country are members of unions, trade unions, who are prepared to strike, to shut down, to use OSHA in furtherance of collective bargaining. For many of them, their unions represent them, whether it is in pension discussions and ultimately on pension plans and pension management plans, and in the collective bargaining process represent them. Their unions represent them in the industrial court if there is a trade dispute or otherwise. But Madam President, nobody represents the legislators. And sometimes we have legislators who for most of their careers are conflicted. They are unable to negotiate for themselves. And the Salary Review Commission does not address the issue of pension. So who represent these legislators? To whom do they turn? I am not going to benefit from this. Many of us here in this house are not going to benefit from this. But these are legislators who have served. When they served, they could not represent their interest. And now that they are out, they are in a worse off position. And I've worked in environments, Madam President, particularly manufacturing environments. I've worked in factory environments where engineers come and demand a piece of machinery costing millions and millions of dollars. And boards have no problem approving that. But when you ask for something for employees in the form of training or in the form of better opportunities, people always try to nickel and dime. And this is not about affordability. This is not about affordability. Maybe it means building one less road or thieving one less million. But I'm very clear in my views, Madam President, and I'm very consistent in what I'm saying, that all legislators who are no longer in these houses of parliament, and even when they were here had no one to represent them, have us today in this house to represent them. And as the Prime Minister has said, this is a matter of principle. This is a matter of principle. And for that reason, when it comes, my other colleagues have spoken to in relation to the judges, Prime Minister and the President, Her Excellency the President. Madam President, legislators who are no longer in these houses should be treated fairly. In relation, Madam President, to the central bank, Madam President, yesterday was Father's Day. And I always go through my father's archives. He's not with us anymore. And many years ago, there was something I stumbled upon. The 1969 publication of all the public service positions, the holders of the office, the date of appointment, and the monthly salary. 1969, that was transparency. Just as the Let's Diary came in a hardbound form, this was issued every year. Madam President, if you look at Canada, every province has a piece of legislation called Public Sector Disclosure of Salaries legislation, every one of them. And many of them are required by law to publish in a nationally circulating Sunday newspaper the details of the salaries of every person in the public sector who earns, in some cases, more than $75,000 a year, and in some cases, more than $100,000 a year in the case of Ontario. And it is every public sector employee, every crown enterprise, the equivalent of our state enterprise, every school, every university, every college, required, every municipality, not just the salaries, you know, Madam President, reimbursements made during the year, expenses incurred on account of travel, and various allowances must be disclosed for all to see. And if it wasn't a secret in 1969, it should not be a secret now for anybody. Because we in this house, as I say in Trinidad, all our business on the road, everybody know what legislators receive. Everybody know what ministers receive. And I do not see, I am actually quite surprised that this ability of the central bank to shield what is basic information. This is not the Angostura bitters recipe. The basic information, what somebody is paid, what is the org structure. What could be so fascinating about the central bank org structure, Madam President? Without much effort, I think I could draw that. The org structure. What could be so fascinating about that? About the salaries, about what could the Minister of Finance, what interests could he be serving except the public's interests? And as he has said in the other place, and he said today, it is my colleague, Mr. Obika, this is the Obika clause. Because it's because of a question that my colleague,
Just ignore him.
because of a question that my colleague asked, the Minister of Finance realized that what could only be archaic and contrary to the public interest exists in the law, and it has to be changed. There was a matter recently, a Freedom of Information matter, involving another NEC relating to the resume of somebody who was appointed president of NEC. And the matter, I believe, went to the Privy Council, or the resume, Madam President. You could go on LinkedIn and see most people's business. What could be so amazing or secretive about the CEO of a corporation that is funded by the state that it cannot be disclosed? Well, the central bank is no different. And I do not think we need to argue a lot about Clause 9. Madam President, Clause 8, national insurance. The Minister of Finance in the other place on here, he has said it. Of course, we want to assist the Venezuelans. We want to assist, and this country has done what it could do to facilitate the Venezuelans. We've gone through a process of registration which will allow them to get a waiver of the work permit requirement and will allow them to seek employment in the country. But the minister has said, this cannot be in trying to assist. We cannot hurt the long-term interests of the rest of Trinidad and Tobago by causing a run on the National Insurance Fund. We who sit here know the situation with the National Insurance Fund. We know the challenges. We know the performance.
She said making profit.
We know the performance of national insurance. And we cannot, on the basis of somebody making 10 contributions to the national insurance, give access to a benefit that goes way beyond the 10 contributions. For example, the maternity benefit. So, Madam President, this is not about emotions, and I cannot, my friends, confound me. Confound me. You do not want the process of registration of the migrants. You do not want that. You don't want them here. The government has no policy. We don't know what we're doing. Then you want us to extend and encourage the most disgusting protest outside the Oval on the second to last night. The most disgusting to be associated with that foolishness. To be funded or whatever. I don't know what part you took in it. But I passed through there. And I could not imagine these well-oiled and well-heeled Trinidadians having the time to go out there to terrorize the Venezuelans in their moment of distress. Rank foolishness, as they say. And then come back here today and talk about seeking the interests of the Venezuelans. This government has sought the interests of the Venezuelans on behalf of the right-thinking citizens of this country. But we've also accepted that there is a point to which we cannot go. We cannot go to that point. And the legislation is meant to give the minister by order, the power by order, to make exclusions to the requirement for those who are employed in this country to make contributions to national insurance. Which brings me, Madam President, to this freedom of information and some of what I've heard. My colleague, a very tamed version of Senator Mark today. Must be because it's a Monday. Reference to the FOI czar, which only, of course, brought me to the Reshmi czar. But, Madam President, I listened to Senator Hussein. And I want to say this, Madam President. The starting point of the proposed Clause 7 is the act that it seeks to amend. That's the starting point. And anybody wanting to go into 7 should go into the act. Because the objects of the act, this Freedom of Information Act, Madam President, has one objective, which is to grant access to information that is in the hands of public authorities. That is what it is. It's not for anything larger than that. But one of the things you must know in approaching the Freedom of Information Act, one of the things you must be very clear in your mind, is that this FOI is not a free-for-all. It is not every piece of paper in this country that is accessible. In fact, Madam President, in this legislation, there are more things that you cannot access than things that you can access. So let us get it very clear in our minds. For those who sit opposite me who have been telling the people out there that FOI is a free-for-all, it's not a free-for-all. It's well-constructed legislation that gives access to information that is in the hands of a public authority, but includes a series of exceptions and exemptions. The second thing is, Madam President, there's been this talk about politicizing freedom of information, and that the Attorney General, in his involvement, is politicizing the process. I'm very shocked. Madam President, Section 3(1)(b) of the Freedom of Information Act, the act that the proposed clause 6(7) seeks to amend, sets out the right of the members of the public to access information in the possession of public authorities. But it also says that this right is limited only by exceptions and exemptions necessary for the protection of essential public interests. So the exceptions and exemptions target two things. One, essential public interests, and two, private and business interests which exists in relation to information provided by a public authority. And Madam President, once you come across this thing called public interest, it necessarily engages the Office of the Attorney General. Because I had to go back to the website, for example, of the Attorney General's website, and it is in the exact form as it was through several Attorneys General, including Mr. Ramlogan. And it is simple and well written. The Attorney General of Trinidad and Tobago has a dual role. He's a member of government with two separate constitutional roles, a government role and a role as a guardian of the public interest. In his governmental role, he acts as a member of the government in the performance of his duties, and in his role as a guardian of the public interest, he acts independently in a quasi-judicial capacity, representing the community at large. Now, Madam President, having said that, I will say that is an excellent exploration of this issue of public interest and the role of the Attorney General in Trinidad and Tobago in defense of that interest. It was explored. One of the speakers before me, I think is Senator Hosein, spoke about Reginald Dumas. And the irony is that that issue was explored at length by Justice of Appeal Jamada in the Reginald Dumas versus the AG case, the matter involving Dumas's challenge of His Excellency's appointment of two persons to the Police Service Commission. And in there, one of the issues in that matter raised was the local standard of Dumas as a member of the public and his peculiar interest in that matter. And one view that was expressed is that it is for the Attorney General to raise these issues. And Justice of Appeal Jamada made the point that in our jurisdiction, it is not, the AG does not, Attorney General does not jump in these matters, notwithstanding his role in relation to the public interest. And that Dumas was absolutely in order to bring this claim because there was no other way something like that would reach to the court. But having said that, Madam President, once you are dealing, and the legislation in 3(1)(b) sets out that the exceptions and exemptions to access to freedom of information are in relation to the defense of the public interest, you engage the Attorney General whether you like it or not, or whether you like him or not, or whether you like this government or not. That is the law. And Madam President, I've listened also to this thing is almost like politician they have no role in this freedom of information. But I would suggest, Madam President, that those who have that view go to Section 22 of the Freedom of Information Act. And Section 22 is very clear, Madam President, very clear, in two aspects. The first is, at Section 22(1) of the Freedom of Information Act, it says, a decision in respect of a request made to a public authority may be made on behalf of the public authority by the responsible minister, a permanent secretary, a head of department, a CEO, or a designated officer. And in relation to the designated officer, the power exercisable by that designated officer is in accordance with arrangements approved by the responsible minister. So I cannot interpret the word minister. It's surely not a minister of religion. It is a minister. The responsible minister is one of the decision makers in relation to a FOI request on behalf of a public authority. And when a minister becomes a decision maker that is reviewable by judicial review or otherwise, the role of the Attorney General as legal advisor to the cabinet is engaged. Where else would a government minister get exercising this public function, making a decision that is reviewable? Where would a minister get advice other than through the Honorable Attorney General? So in that regard, in the exercise of the authority under 22(1), a minister, a politician, can make a decision, and in doing so, is entitled to seek the advice of the Attorney General. Madam President, in 22(2), in certain circumstances, where a decision in relation to an FOI request has not been made, in judicial review proceedings, the court is entitled to deem the decision as having been made by a minister, 22(2). So it is not when a minister makes a decision under 21(1) alone, where the arrangements have not been put in place for a decision to be made, the minister can be deemed to have made a decision. And if a minister, if the statute includes a deeming provision in relation to a minister, then once again, the Attorney General must be engaged. So, Madam President, whether it is exercising his constitutional role in relation to advisor to the cabinet, or whether it is exercising his other role as guardian of the public interest in the exercise of the functions under the Freedom of Information Act, not only are ministers engaged, but the Attorney General is already engaged. And what does this section seek to do? Madam President, quite simply, this section, this proposed clause, puts something that helps an applicant, and that something does not currently exist. Because in the current course, a request is made. There is a response or a lack of response within the 30 days. There is a refusal. And what happens if there's no refusal? If there is compliance, fine. If there is a refusal, instead of going through judicial review proceedings, the Attorney General has the opportunity to review the decision of the public authority. And the government is taking on, I think, great risk by going this way to create another opportunity for applicants seeking information from the state. Because the language of this clause, says that the public authority must abide by the advice of the Honorable Attorney General, must. And we are doing something that any government, any cabinet, and any legislator should be very, very careful in doing. But the circumstances set out by the Honorable Attorney General in the other place and the Minister of Finance here, where we find ourselves, makes it necessary, if we are on the one hand to provide responses and to provide the sort of access that the legislation contemplates, and on the other hand, to reduce the litigation costs being incurred, then we must have a clause of this nature to facilitate the process. Madam President, I heard my colleague, Senator Deonarine, talk about reducing the 30 days to maybe 14 days. Well, those of us who have worked in the public sector as ministers or otherwise know that 30 days could become 30 years very quickly. Madam President, I've told the country on tomorrow afternoon I'm going to Rio Claro to distribute some cabinet approvals for leases. Most of those people have been waiting for more than 30 years. I've told the country about Sheila Mohammed from Point Fortin when she whispered to me, Minister, I've been waiting for 60 years. I'm going to Rio Claro tomorrow. I'm going to Chaguanas East tonight. Madam President, for persons who have leasehold interest in state property, the lawyers amongst us would know. In Westmoreland, for example, where the state really has no interest in the running of the towers, if you are disposing of a unit down there, you have to get the consent of the Commissioner of State Lands. And last week I had to intervene, for example, the lady who said her buyer has been waiting for more than 9 months. Wow. The transaction, she needs to dispose of the unit to settle some medical bills that she has to settle. And Madam President, this thing, a consent, a sheet of paper with 95 words written on it, can take months and years. So 30 days in the life of the public sector is like lunchtime for most of us. It's nothing. And much of what, when you think about the ministries and when you think about how ministries operate, the opportunity for a freedom of information request to reach to the desk of a minister or a permanent secretary or something like that, you're talking about months. So that the government has left it at 30 days, but we believe that this opportunity for the review by the Attorney General is an opportunity to maybe have a decision made that would not ordinarily be made. And why do we want to do that, Madam President? The Act itself, the Parent Act, is very clear. It says at 3(2), the provisions of this Act shall be interpreted so as to further the object set out in subsection 1. And any discretion conferred by this Act shall be exercised as far as possible so as to facilitate and promote promptly and at the lowest reasonable cost the disclosure of information. So if there is a refusal and the Attorney General gets the opportunity now to intervene and in 30 days review the refusal, there may be what Section 3(2) of the Act asks us to do, to facilitate, to lower the costs, to do things in a prompt manner so that information could be accessible where the Act itself says that such information is accessible. Madam President, I also want to make the point that even the freedom of information, we were in a joint select committee. We are in a joint select committee which recently interviewed the permanent secretary in the Ministry of Communications. And that is the ministry where the Freedom of Information Unit resides. And I asked her a question. I asked the permanent secretary about the vacant positions in the FOI unit. about contracts in the FOI unit that are going to expire shortly. And the FOI unit and the FOI people, where they exist in ministries, are no different from the rest of the public service. They all sit and wait in hope that an HR division somewhere will cast the light upon them and renew their contracts or continue their contracts or fill vacant positions. So many of these units, and this unit itself, has its own challenges in relation to resources. So we would like that in one day. We would like that you can email a request and get an answer immediately. But I sat here a while ago and sent an email to an institution and had to leave here and go to the institution and say, I sent you an email
Minister,
a few hours ago. So it does not, it does not necessarily work so. So, Madam President, in relation to my colleague, Senator Hosein, when he talks about the FOI clause seeks to restrict information on the way the government operates. The government has no interest in restricting. The Act provides. The Act is very clear. The government doesn't like to go to court. The Act sets out what is accessible and what is not accessible. What we are seeking to do is to do what the Act asks of us, to make decision-making a little faster, to reduce the cost, and to allow decisions to be made in relation to the Attorney General's requirement that he acts in the best interest of the public. I read the same press release about the lawyer bashing, and the Law Association offered no commentary on the way this clause could work or the way we could improve the FOI process. All their commentary was targeted to what they perceived as lawyer bashing. I listened to my colleague quoting Ramesh Lawrence Maharaj, who talks about a political hand will now be responsible for reviewing confidential information. Well, by nature, the job of a minister, the functionaries in a ministry, we are required to get into confidential information, and that is nothing new. This is nothing new. But the Act is very clear of what could be done and could not be done. And if we had focused on those words contained in the clause, all of us might have been home a long time ago. And the question of why does the AG want to interfere? The nature of the Attorney General's role is to interfere, especially when you're dealing with public authorities, to interfere, to intervene. The advice that is given comes via the Office of the Attorney General in many cases. That is the role of the Attorney General. And you may not like personalities, and you may have your own fears and so on, your own concerns, but it has been like that in the history of the position of Attorney General in this country, and the government does not wish to change that in any way. So, Madam President, I would say in conclusion that the amnesty, there is not much to be concerned about. This is something that has been done before. The FOI, I have a particular view on it, and in relation to Section 22(1) and 22(2) of the Parent Act, and in relation to Section 3(1) and 3(2) of the Parent Act, I think that what we're doing here is consistent with that. The national insurance provision, I believe that we have to strike the balance in relation to our willingness to accommodate Venezuelans, but we must also protect the long-term health of our national insurance fund. The Central Bank of Trinidad and Tobago, I think they've been lucky that the Minister of Finance did not have sight of that provision, but I think that their luck should run out, and the public should have access to that information, not just the minister. And the two provisions in relation to the Companies Act and the non-profit legislation that we just passed, I consider them to be administrative, to grant the minister the discretion to extend the time within the safeguards that exist in the proposed clauses 10 and 11. I thank you, Madam President.
Honourable Senators, we will now suspend the sitting and we will return at 5:35 p.m.